Hi there, I'm Jack Price. I teach civil procedure at University of Richmond School of Law. My task right now is to help you tackle a summary judgment question. All right, a summary judgment question. What in the world is summary judgment? Well, it simply means judgment before trial or judgment in summary or cursory fashion. Now, cursory doesn't mean it happens quickly, it just means that it happens more quickly than trial. How does summary judgment work? Picture for yourself an ordinary claim between a single plaintiff and a single defendant for a car accident. Now, I will explain, that you may learn and know that any party can move for summary judgment. But the most common way that summary judgment works is the plaintiff bears the burden of proof to prove his or her claim, and the defendant is the one who says your claim is lame. Your claim is lame, right? And the defendant is the one, therefore, most often moving for summary judgment. Don't be distracted that plaintiffs can sometimes move for summary judgment. It happens. But for the purposes of our illustration here, we're going to go with the most common way that it works. It makes it a little bit easier to explain instead of referring to movements and non-movements all the time. But don't forget that point. Okay, so we've got a basic lawsuit. Plaintiff says the defendant ran a red light and got into a car accident with her. What should you do? Let's say you're the judge analyzing this. The first thing you do as the judge is you say, defendant, I understand you're moving for summary judgment. I'm going to figure out whether you've met your burden. The defendant says, well, really, what is my burden? And the judge says, your burden is this. Your burden is to point out to me gaps in the plaintiff's case that means that no jury could find in her favor, or to adduce new evidence to me suggesting that the plaintiff will not prevail at trial. Okay? So again, your burden, defendant, says the judge, is to adduce new evidence to me or point out gaps in the plaintiff's case. How might the defendant do this? The defendant says, okay, judge, here you go. Here's my motion. The judge opens it up, and the motion is filled with citations to admissions in the record, to deposition transcripts. There are parts where the defendant's attorney said, now, plaintiff, when you were driving on that particular day, were you wearing your glasses? No, I wasn't. Is there anyone else that saw this accident? No, there's not. Are you aware of any other video evidence pertaining to this accident? No. Do you have any other evidence that could show that the defendant actually ran a red light? No, I don't. Well, if that's the case, why are we even going to trial? I mean, that would just be a routine that's unnecessary and wasteful. So that's one thing the defendant could do, show all the gaps and missing pieces of the plaintiff's case. That's not the only way the defendant can clear his burden, though. The defendant could also adduce new evidence. Suppose the defendant says, listen, I've got one of those GoPro cameras, and I'm so vain that I videotape everything I do. I've got one on my forehead every single moment of my life, even when I'm asleep. It's ridiculous, but I'm addicted to it. Right? So the court, he attaches this video to a motion for summary judgment. The court looks at it, and it says, I'll be damned. The light was green in your favor. That's fantastic evidence. Okay, so the court then says, has the defendant shown enough gaps in the plaintiff's case or adduced evidence sufficient for a jury to say, oh, the defendant's definitely not liable? If the defendant's done that, then the court says the defendant has cleared his burden. That doesn't mean the court grants the motion. It just means the defendant has cleared his burden. So then the court turns to the plaintiff and says, now, plaintiff, I just talked to the defendant over here. He pointed out a lot of gaps in your case, or he showed me this really great GoPro video of the light being green in his favor. Now it's your turn to respond. To survive summary judgment, the plaintiff has to come up with evidence. Evidence, right? Evidence, stuff that can be admissible at trial, not arguments. The plaintiff might have all sorts of explanations, but it has to be evidence. So the court will look at the plaintiff's evidence, and it will do so with a particular attitude or frame of reference. And that is this. First, the court only looks at the plaintiff's evidence in isolation, does not compare it to the defendant's evidence. So it could be that the plaintiff has 3 witnesses saying that the light was green in her favor. The defendant has 350 witnesses saying it was green in his favor. Wow. Looks like the defendant has the better of the argument. The court doesn't care. the court does not weigh the evidence. Right? As long as the plaintiff's 3 witnesses are enough for a reasonable jury, that's fine. Or put this way, the judge says to himself, if we had a trial, the plaintiff put on her 3 witnesses, and then for some reason the defendant just stopped and said, I rest, no defense. Would the jury have enough just on those 3 witnesses to say you did it? To say the defendant was liable? Probably. I mean, if you were sitting on a jury and you only heard from 3 witnesses, but all 3 of them said the same thing, yeah, the defendant did it, the defendant did it, the defendant did it, well, I think the defendant was liable. Now, there may be 350 other witnesses out there, but I never heard from those, right? So the judge pretends that he knows nothing about those 350 witnesses. Okay, so the first thing the judge does in looking at the plaintiff's evidentiary proffer in response to the defendant's motion that the defendant has already cleared his burden for is look at the plaintiff's evidence all alone. The second thing that the judge does is assume the plaintiff's witnesses are truth tellers. Assume the plaintiff's witnesses are truth tellers. In other words, the judge does not make credibility determinations. The judge might say, well, listen, plaintiff, you've offered me some evidence here, but this guy is known around town as a real liar. He's a drunk. He's a liar. He has no respect in the community. Well, that's not for the judge to determine. The jury gets to make credibility determinations. We may have a great guess as to how the jury will consider the testimony of this particular disreputable man. But that's not a guess that summary judgment law permits. Okay, so the judge looks first at the defendant. Has the defendant cleared his burden by pointing out holes in the plaintiff's case or adducing new evidence that suggests he's not liable? Once that happens, and successfully happens, the court says, okay, plaintiff, show me some evidence, real, live evidence. And the plaintiff tries to do that. The court looks at that evidence alone, doesn't compare it, and assumes that any of that evidence from witnesses is told by truth tellers, that the jury will believe it. Now, one final point on admissibility, right? This evidence, I keep saying the plaintiff has to respond with evidence. That stuff has to be admissible. Now, the plaintiff can respond with affidavits, even though affidavits aren't technically admissible in that form. So when we think about admissibility of evidence, we're thinking about the content of the information produced to the judge on summary judgment, not the form in which the information is produced. Right? So you can't go in front of a jury and say, Your Honor, or ladies and gentlemen of the jury, here's an affidavit that proves our case. That's not the way it works. You put on the real witness, or if the witness isn't there, you throw on some deposition testimony or something like that. You don't throw on an affidavit. No one can cross-examine an affidavit. So you can't do that. But an affidavit still works as a proffer of evidence because the information contained within an affidavit is admissible. Now, if information inside an affidavit is hearsay, that part is not admissible. Okay. That is how you tackle a summary judgment problem. You start with the defendant in isolation. If the defendant clears the burden, you move to the plaintiff. Look at the plaintiff in isolation, and you make sure anything she proffers is admissible evidence. All right. Good luck to you on tackling a summary judgment question. Thanks.